This case is the perfect example, not only of Congress creating the bloated administrative state, but also of the courts placing the imprimatur of legitimacy on their actions. From Thomas's dissent, this case exemplifies the problem. Congress purported to empower an administrative agency to impose whatever workplace-related safety standard it deems appropriate. That power extends to virtually every business in the United States. Congress literally handed over the keys of the regulatory system over to OSHA by allowing them to create any standard they deem appropriate with little if any oversight, review, and certainly no due process. The agency claims authority to regulate everything from a power lawnmower's design to the level of contact between trainers and whales at SeaWorld. Not only does OSHA claim the authority to regulate every aspect of the workplace, but to overrule the Constitution itself. Specifically, Title 29, Section 1903.3 of the Federal Code of Regulations claims compliance, safety, and health officers of the Department of Labor are authorized to enter without delay and at reasonable times any factory, plant, establishment, construction site, or other area, workplace, or environment where work is performed by an employee of an employer. Anyone heard of the Fourth Amendment, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated"? Who cares if a search of someone's business is reasonable or not, or if there's probable cause or even due process? This group of unelected bureaucrats claim that the Constitution does not apply to them. And if you refuse to allow them to illegally search your business, guess who gets to review the refusal? Upon a refusal to permit the compliance, safety, and health officer in exercise of his official duties to enter without delay, the compliance, safety, and health officer shall endeavor to ascertain the reason for such refusal and shall immediately report the refusal and the reason therefor to the area director. The area director shall consult with a regional solicitor who shall take appropriate action, including compulsory process if necessary. That's right. The very same agency attempting to illegally inspect your business reviews your objection to it. Please notice, none of these powers are recorded in the laws of the United States because they are not law. They are merely regulations impersonating laws and used to destroy your rights. The Occupational Safety and Health Act may be the broadest delegation of power to an administrative agency found in the United States Code. If this far-reaching grant of authority does not impermissibly confer legislative power to an agency, it is hard to imagine what would. Thomas is correct. If OSHA isn't the greatest abuse of power both by Congress in creating it and in the agency by how they wield said power, I don't know what is. I can think of no other act by Congress that so exemplifies the 10th grievance listed in the Declaration of Independence. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. Just imagine if other agencies had similar discretion. It would be no less objectionable if Congress gave the Internal Revenue Service authority to impose any tax on a particular person that it deemed appropriate, and I doubt any jurist would sustain such a delegation. Again, Justice Thomas is correct. Yes, as inconceivable as this law is, the 9 justices on the Supreme Court could not muster the 4 votes needed to even hear the case. That, ladies and gentlemen, is not only inconceivable to me, but apparent dereliction of their duty of the highest order. The question whether the Occupational Health and Safety Administration's broad authority is consistent with our constitutional structure is undeniably important. At least 5 justices have already expressed an interest in reconsidering this court's approach to Congress's delegation of legislative power. Because this petition is an excellent vehicle to do exactly that, I would grant review. Justice Thomas then listed 2 cases, Paul v. United States and Gundy, where Justices Kavanaugh, Alito, Gorsuch, Roberts, and yes, Thomas himself have questioned Congress's delegation of legislative power. So why couldn't this case get the 4 votes necessary to review? We may never know.